G'day everyone and welcome to video 3.2.12 for the Legal Studies guy. Getting a long way through Unit 3. I'm sure you're like me and wondering where the time has gone as we are almost on the cusp of Unit 4. A quote today from the famous author Aldous Huxley: "Every ceiling when reached becomes a floor, upon which one walks as a matter of course and prescriptive right." AKA, in simple terms, set yourself goals, set yourself lofty goals, and when you reach them, when you reach that ceiling, when you reach what you thought was unattainable before, or you thought was, your limit, from then on you will walk on that ceiling, and that will be your baseline, and then you'll go again. It's about setting goals, but reviewing and setting, loftier goals after that, learning what you're capable of, and continuing to go that step further. And it's definitely something you can do from SAC to SAC in year 12 classes, is set yourself that lofty goal, and once you reach it, be like, this is my new baseline, this is the lowest it gets, and I'll try and go up again from here. So as I said, today we are 3.2.12, so second last dot point for Unit 3. And it's much like the 3.1 for the criminal justice system. Our second last dot point is factors that affect the ability of the justice system to achieve the principles of justice, so to achieve fairness, equality, and access. And it gives us some specific things, including in relation to costs, time, and accessibility. And this is all feeding into our ability to evaluate whether the civil justice system achieves the principles of justice. So this is just giving you some extra ammunition, I suppose, around, why the justice system sometimes isn't fair, why it sometimes isn't accessible, and why it sometimes isn't equal. So really just building off, the stuff we've done with previous dot points when we've looked at pre-trial procedures and how they actually might hinder the principles of justice sometimes. And we've looked at damages and how they might hinder the principles of justice sometimes. This is just building on that. The essential question that we'll be able to answer at the end of today is: what factors stop the civil justice system from achieving fairness, equality, and access? So, as we just said there in the first slide, very prescriptive, and it gives us three things that we need to talk about. The first of those being costs. And this is effectively the same information as you were given around criminal stuff. And it has the same impact in civil law, and that's just the idea that the costs of pursuing civil action, or the costs of defending yourself in a civil action, can be exceedingly high, and this can really impact your access to the justice system. Can also affect the fairness of the dispute, because you might not have appropriate legal representation, which therefore is also a lack of access. I don't mean a lack of equality if you're not on the same standing as the other party. So costs are really driven up by the need to have that legal representation. We know that generally law firms, for any behind-the-scenes solicitor work they do, will charge you out around the 200 to 800 per hour range, and generally that's charged in 6-minute blocks. So that's obviously going to build up pretty quickly if you've got someone working on a civil case for you. If you're at the upper range of that and they have to put in 25 to 30 hours of prep work, you are already around the $16,000 to $20,000 range. You've then got the fact that you've got to get a barrister to actually argue your point in court, and they can cost $1,000 or more per day. So we've mentioned it a few times, but the Rebel Wilson case, she hired a barrister who was worth $9,990 per day for what ended up being a couple of weeks in court. So extensive costs, particularly if you're using high-end legal representation. And then you've just got the filing fees, the cost to initiate a claim. So over $1,000 in the Supreme Court. The cost of filing a writ in the county court at the moment is $851.80. You've got to pay for each day of the hearing. You've got to pay for any documents you you want to access, any subpoenas you want to enact. You have to pay 60 cents per page for every piece of photocopying that occurs. If you want a jury, particularly say in a defamation case, you've got to pay for that as well. So then there's all those court costs that just add on to this. So this builds onto this, which builds onto this, which puts you significantly out of pocket. The other aspect of costs is that long process, so particularly discovery, directions, hearings, they just add to the costs, and we'll talk about them a little bit in delays as well. So when we talk about time or delays, again, this whole justice delayed is justice denied vibe, and it is important to note that 85% of matters are resolved within acceptable timeframes across the civil justice system. So we are getting, that, 8 or 9 out of 10 right. It's just that for every set there is one case that perhaps isn't being resolved in a time frame that's acceptable and isn't being resolved quickly enough and causing that added stress and those added burdens. And as I just talked about, that often comes down to the long process. We build fairness through allowing each party to see the other party's evidence and claims, but it can have a really negative impact. So discovery is a particular one where one party can really abuse the system. They can create delays through the use of interrogatories. I was actually chatting with a lawyer last night who's a solicitor for Morris Blackburn, who's one of the firms that does a lot of the big class actions. And she said, quote, we use interrogatories extensively, so the lists of written questions, we use them extensively. Do they serve any purpose for us? Like, do they help us with our case? Hardly ever, but we still use them. And the real reason for that is the fact that they add time and they add work to the other party, and they add costs and they add stress. And if one party's constantly doing that and adding in all of these steps to discovery and requesting all of these documents, that process gets dragged out, the trial date gets pushed back, and that can really have an impact on the access and the fairness side of things. And you've just got the whole idea that the legal system has just an increased load, like more cases than ever, so longer waiting times. I'm going to link you to a criminal article at the end, so not as relevant to civil as it could be, but lots of stuff in that, just about, the growing need or the growing demand on the legal system in all facets. Finally, you've got accessibility. So this is where we differ from the criminal side of things. The criminal law or the criminal justice system section of the study design wanted us to look at social differences here. So now we're just looking more generally at accessibility. And social factors, economic factors, all these different things mean some people can't have the same level of access to the justice system as others. And that could be cultural, or that might be to do with gender. So cultural barriers, there's a lack of interpreters, which is something we looked at with the criminal justice system. So if you are a migrant or you are a non-English speaking background, Australia is a very multicultural place. You might not actually be able to access the legal system because you can't understand what's going on and you can't get an interpreter. There's also, with Indigenous Australians, particularly those from remote communities, they might just genuinely not understand they have civil remedies available to them. Might not understand they can actually go to the courts to have some form of harm rectified. And that cultural idea of just, I suppose, acceptance of things that are happening to them, as opposed to seeking some form of restitution. So that's another cultural difference that impacts accessibility. With women, it's often to do with family law matters, particularly instances of domestic violence, where women really feel like they don't have the same level of access to the justice system as males. This can be particularly within some family law or in most family law matters. There's a real preference to try and use mediation and conciliation to resolve things like custody disputes and divorce and stuff, which can be really, really tricky if there has been any domestic violence. It can be really confronting and stressful for the female or the male if they've suffered domestic violence as well. And our justice system hasn't really it's not really prepared for this sort of stuff. You've also got the idea that with stereotypical gender roles, and we know there's still a gender pay gap in Australia, that women just have less financial means often to access legal support in family law matters. If they haven't worked, if they haven't been the breadwinner, they might not actually be able to financially gain representation to support themselves in a dispute. So there's lots of issues with accessibility there for females. Our skill is to evaluate the ability of the civil justice system to achieve the principles of justice. So we obviously usually do this, but literally everything we've just gone through feeds into this side of the table. So you can fill that one out yourself back from those previous slides if you'd like. In terms of looking at hypothetical or actual scenarios, so as I said, I've linked you to a criminal law article. It was written in April, so it's going to help you with the criminal law factors as well. But it's about the fact that we have a larger prison population than we ever have, and almost 50% of these are people who are on remand, have been denied bail because of new tougher bail laws, and just the impact that's having on the justice system, increasing the load of the justice system and the costs for the state, which is going to have some impact on the civil law system as well. The other one is just a link to the fees page from the county court, and this has a list of all the fees. So $851.80 to file a writ, and then your hearing fees, your document fees, and all that sort of stuff. So I'd recommend having a look at that. You'll be able to find a similar page on the Magistrates Court website and on the Supreme Court website as well, which I'd recommend just having a look at to see what the costs actually are, and almost start to calculate in your head, if I pursued a dispute, what sort of money would I be looking at? If it's a 5-day trial or a 6-day, etc. So, in conclusion, can you or do you understand what factors stop the civil justice system from achieving fairness, equality and access? That being costs, time and accessibility, and can you explain them and use examples to get that point across? Hopefully you can. If not, re-watch this, have a look at your textbook, have a talk to your teacher as your first point of call, and see how you go. Love it if you could subscribe to the YouTube clips, subscribe on the website as well, and we'll get some subscriber emails out, particularly as we get into Unit 4, and start getting some content out for that. This has been another video for the Legal Studies guy. A bit shorter than usual, hopefully, so we've got plenty of time to do 3.2.13. As I said, make sure you subscribe, and thanks for